YouTube, it's Tone back with another one for you. This one is a pretty good one. So this is a document related to revocation of election to be a taxpayer, right? And so this here has the first page, which you're gonna see. And anybody who wants to document, email me is free, right? So on the first page, you're gonna see some flawed tax arguments to avoid. So if you're engaged in like a back and forth paperwork with the IRS or whatever. These are some links here that you can go to find flawed tax arguments, which a lot of people try to teach, and they'll just end up getting you fucking locked up. So this is all shit you don't want to do. So check out these links here. Also, there's like a warning on this too, saying that the people who made this particular document were offering services, which apparently were a scam or some shit like that. So be careful with that, right? So we'll go ahead and get to the next page here. Let me write this down. So right here, we get into revocation of election established by the U.S. Congress. So the purpose of this statement of facts is related to the opinion provided by the U.S. Congress, providing American nationals, referred to as non-resident alien individuals, in Title 26 statutes and regulations, to terminate the former sub silentio, otherwise known as voluntary election, which is what we do a lot of the times without realizing when we're contracting, without getting full disclosure of what is actually going on when you're contracting with these agencies. So the foundational basis for revocation of election, and it's all based on this. So you're going to have some court cases here that are being referenced, and it's giving you the indicators uh, of what the Supreme Court justices use to make their rulings in this particular case. So the canon of construction, which teaches that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States, which we all know is the 10 by 10, 10-mile square in Washington, D.C., right? Is a valid approach whereby unexpressed congressional intent may be ascertained. It is based on the assumption that Congress is primarily concerned with domestic conditions. Domestic meaning that only things that relate to them. So Westlaw provided the following summary of the Foley Brothers Inc. versus Falardo case. It is well established principle of law. All federal regulations and statutes only apply within territorial jurisdictions of the United States, the District of Columbia, unless a contrary intent appears, meaning of implementing regulations are published in the Federal Register. The Internal Revenue Service operates under Title 26, the Internal Revenue Code, statutory laws, and its lesser known administrative, procedural, and implementing regulations regarding federal income taxation found in Title 26 of Code Federal Regulations. These federal statutes and regulations used by the Internal Revenue Service are applicable only within the territorial and legislative jurisdiction of the District of Columbia per the U.S. Supreme Court. Thus, the IRS statutes and regulations are specifically limited in their geographical jurisdiction as well as the legislative jurisdiction for the application toward those who are the proper federal taxpayers, quote unquote taxpayers, as expressed in the IRC at 26 USC Clause 7701A14. The limited geographical and legislative jurisdiction for IRS statutes and regulations is restricted to the District of Columbia by the legislative intent on the 16th Amendment. Statutory taxpayers are defined to mean any person subject to any internal revenue tax. And obviously, this is all going to be based on the structure of your entity that you use to conduct business, right? These are all going to have different regulatory and statutory codes that are going to dictate the way that you're supposed to file and things like that. So defined at 26 USC refers only to a statutory legal fictions created by and under the dominion of the U.S. Congress. The statutory term subject to means under the dominion and control of the national government. Established by the Constitution, the American people are the sovereign, right? And you should know that. As such, the United States Supreme Court has declared in Yick Wo versus Hopkins that sovereignty itself is, of course, not subject to the law, for it is the author and source of the law. It is therefore an imperative necessity to include the statement of legal opinion expressed by the United States Supreme Court in United States versus Cooper Corporation, in which the court stated, since in common usage the term person does not include the sovereign, statutes employing the phrase are ordinarily construed to exclude it. Thus, the statutory definition of person found in 26 U.S.C. and referred to in the statutory definition of taxpayer 26 U.S.C. 14 does not reflect or include in any fashion a reference to the American national who are the identified sovereigns by birth in one of the 50 states of the Union, those naturalized or from parents who were born there. So you see, by just being born in your particular area, assuming it's in one of the 50 states, gives you sovereignty just due to the fact that you were born there, along with rights to all of the minerals and things like that too in your particular domain. But those have to be claimed as well. And we're going to be getting into that in the next couple of months. We're going to be getting into how to convert your person into a Article 4 person, and then you'll be able to go ahead and claim all of your, securities and things like that, and liquidate assets from contracts that you didn't even know existed. All right. So right here we have revocation of election established by the U.S. Congress. Let it be known that the Internal Revenue Service, a federal bureau headquartered in Washington, D.C., has promulgated in Title 26 of the United States Code, USC, a statutory legal option for those who are non resident aliens to implement the termination at their discretion to any voluntary federal income tax election established at 26 USC Clause 6013G election to treat non-resident alien individual as resident of the United States. Now, keep in mind that the word resident in general is a commercial term, right? So whenever they ask you where your residence is, they're really asking you where you do business. And when you answer accordingly to that, you're basically admitting to doing business, all right? So that's why it says a non-resident. It doesn't mean that you don't live there. It means that you're not doing business there. So once a statutory election under 26 USC H was initially established, those non-resident alien individuals who made that election immediately became a federal statutory taxpayer, and their former non-taxable income is then deemed taxable in an identical manner to those of a U.S. resident alien. The election also became automatically applicable for all taxpayers following as stated at 26 USC 6013 duration of election. The non-resident alien individual thus became voluntarily liable via this election for a tax never levied upon them, and their entire private sector employer paid wages were taxed under Chapter 24 of the Internal Revenue Code. This wage withholding taxation was also automatically applicable for all taxable years following the initial election. As part of the duration of election section at 26 USC 6013 G3, the statutory term non-resident alien individual is defined at 26 USC Clause 7701 B1B and is expressed in this statute in the following manner. The definition is available on cornelleducation.com as well. So this is all things that can be verified. An individual is a non-resident alien if such individual is neither a statutory citizen of the United States District of Columbia per 26 USC nor a resident alien or foreigner from another nation of the United States District of Columbia. What was immediately noticeable is that the definition only tells the reader what a non-resident alien individual is rather than what is. Such purposeful obfuscation is vitally important to recognize, and that's true because they do make things so vague that it can be open to interpretation, which is not law. Okay, and that's how you know that it's not law because it's not really specific, right? It's telling you what it isn't. It's not telling you what it is. The true meaning of the statutory term non-resident alien individual is none other than American nationals who were born in one of the 50 states of the Union, the constitutional republic. All right. And this is what we live in. We live in a republic. And these people try to confuse you all the time by talking this Democrat shit and democracy fucking nonsense. These people are out of their fucking mind. And that's all part of their brainwashing shit. So this is amply illustrated in reading 26 CFR 1.871-1B4 expatriation to avoid tax, right? And this is all part of the UCC package that we offer as well, which can also be found for free online. One Man Out. Check that book out. It'll tell you how to change your election as well. And it goes into detail as far as the UCC one goes, security agreements, and all that. So this regulation section reads as follows. For special rules applicable in determining the tax of a non-resident alien who has lost U.S. citizenship with a principal purpose of avoiding certain taxes, see Section 877. In regard to the expatriation, only American nationals, those born in one of the 50 states of the Union, can give up their constitutional U.S. citizenship status and become a former member of the constitutional republic. So basically, anybody who moves here from another country cannot become an American national because they were not born here. Therefore, the term non resident alien individual and American national are synonymous. So it's the same thing. Whenever you use any of the terms non resident alien individual, quote unquote, and quote unquote American national, same exact thing. All right. So when you see that, you already know. The legislative intent of the 16th Amendment of the Constitution written by former President of the United States William H. Taft, documents that Congress was only able to levy the federal income tax upon the national government itself, and that's one of the big things too. And I forget what exactly the code is, but I think it's 27 USC or 17 USC. It's one of those two that you're gonna find when you read that they are only able to levy, which means tax and or when they take money out of your checks and shit like that, levying your checks, they're only able to do that to actual federal government employees, not to the actual nationals. And so that's something big to know too. So the Internal Revenue Code is only applicable in the District of Columbia and U.S. territories for those born there, those who work for the national government, and those who are U.S. resident aliens. So you see what it is. Those are the only people who are able to be taxed. So people who came here from another country, became a U.S. resident, and things like that, they're going to be subject to tax, not us who were born here. Okay. So note the use of the term American national is a non-statutory phrase created to eliminate confusion with the statutory term U.S. citizen, as referenced in various sections of Title 26. It means those born in one of the 50 states of the Union, those born to parents of which are at least one of those who were born in the 50 states, or those naturalized into the constitutional republic. So those are the only people that are going to be tax exempt. All right. And there is a process for all that. So, former POTUS TAP stipulated in the foundational document, the legislative intent of the 16th Amendment, that the decision of the Supreme Court, Pollock versus Farmer Loan and Trust Company, in the income tax case, deprived the national government of a power which, by reason of previous decisions of the court, it was generally supposed that government had. I therefore recommend to the Congress that both houses, by a two-thirds vote, shall propose an amendment to the Constitution conferring the power to levy an income tax upon the national government without apportionment among the states in proportion to the population. The power to ignore the Constitution only exists in a jurisdiction in which the Constitution does not apply. The only jurisdiction is the 10-mile square area referred to in the Constitution as the District of Columbia. Non-resident aliens, quote unquote, American nationals, the same thing, are only liable for the federal income tax if they choose to make a statutory election. So that shit is all optional, okay? Describe that 26 year. And so this is one of the big things too that people don't realize. And so look, so if you're going to try to, become a non-taxpayer or whatever like that, you're gonna have to go through a paperwork process and put them on notice. You can't just stop paying and wonder why they're fucking taking you to court and levying your property and fucking, stealing your house and things like that. There's a process for all this because you entered into a contract, whether you realize it or not, and you would have to end that contract before you could start doing something like that because you do have an obligation at this point if you did in fact contract with them to become a taxpayer. And it isn't even a big deal because if they send you a bill, you already know all you got to do is fucking endorse the bill and send it back to the treasury. It's not even that complicated. Blows my fucking mind why people even let them shits get out of control like that. It's crazy. It's crazy. So what do we got here? Classification of aliens by filing a form 1040 U.S. individual income tax for a tax they never were made liable for prior to the election. So the first time you filed a 1040, that's when you opted to give them a donation and then became liable for the federal tax for the federal taxes per Clark versus United States. So this is all part of that. A statutory election is not a valid contract. All right. And so these are the big things too that you need to ask them for the contracts and where they told you that you were going to be obligated to become something like that. And where in the contract did they tell you that you were giving up your rights as soon as you agreed to contract with them? Like who would ever do that? Nobody would knowingly give up their natural God-given rights just to become part of a corporation for what? You know what I'm saying? Come on. Cut the shit. So anyway, via 26 USC Clause 6013G, this statutory election allows the national government to treat or tax the income of those never imposed with a federal income tax. American nationals, aka non-resident aliens, are then treated identical to that of foreigners who are legal taxpayers called US resident aliens who live, work in one of the 50 states of the Union, the Constitutional Republic, or the District of Columbia. So, at what point would anybody give up their rights to not be taxed and be treated like a fucking foreigner? And they act like you knowingly did that, and then they treat you accordingly. All right. So, that's the game. So the lack of tax liability and the right of non-resident alien individuals to choose not to make an election were established by the legislative intent of the 16th Amendment written by the former POTUS, William H. Taft, on June 16, 1909. American nationals have always been lawful non-taxpayers as they were excluded. This foundational document, which clears up the question of just who the parties are that the federal income tax has actually been levied upon, was promulgated in the Congress Record of the United States Senate, pages 3344 3345. The federal income tax was only levied upon the national government. It also ignored the rule of apportionment, a mandatory requirement in the Constitution, further pinpointing that the only operational jurisdiction to be the District of Columbia and U.S. territories. The federal income tax was only levied upon the national government. So you can see what that is, which is to say that those Americans who have chosen to work for the national government in one of its myriad of public offices, performing the functions of a public office, which is the statutory definition of a trade or business per 26 USC 7701. Within the regulations used by the Internal Revenue Service, one can locate the voluntary nature of non-resident alien individual, meaning American nationals, being offered the option or choice to make an election or not. By that fact, the election is a voluntary choice. The option to Americans has not been broadcast to the American public. The voluntary choice to make an election or not illustrates that the national government has been successful in burdening Americans with an obligation that was never imposed by law outside of making an election. 26 CFR 1.871-1 Classification and manner of taxing alien individuals is the regulation in particular that demonstrates the voluntary nature of the American nationals to exercise the choice in making an election to have their income taxed or treated like that of a non-resident alien. Now ask yourself who would voluntarily ever do some fucking dumb shit like that. Okay? So you know as well as I do that nobody did that shit on purpose. We didn't think that we had a fucking choice. All right? So, for the purpose of the income tax, alien individual are divided generally into two classes, namely resident aliens and non-resident aliens. Resident aliens individuals are in general taxable the same as a statutory citizen or legal fictions of the United States. That is, a resident alien is taxable on the income derived from all sources, including sources within the United States. Non-resident alien individuals are taxable only on certain income from sources within the United States and on the income described in Section 8864C4 from sources without the United States, which is effectively connected to the taxable year with the conduct of a trade or business in the United States, meaning only the District of Columbia, per 26 USC Clause 7408D. However, non-resident alien individuals, American nationals, may elect under Section 6013G or H to be treated as a U.S. resident for the purpose of determining their income tax liability under Chapter 1, 5, and 24, the wage withholding of the code, emphasis and clarifications added. The last paragraph above shows that non-resident alien individuals, or rather American nationals are offered the choice by use of the statutory expression may elect to have their income treated or taxed as that of a U.S. resident alien. The expression may elect clear signifies that there is no mandatory obligation to file a 1040 U.S. individual income tax form or pay that tax. Okay? There is no obligation. That shit is voluntary. The lack of a mandatory obligation to file a Form 1040 return and pay the federal income tax is further substantiated by the United States Department of Treasury. The United States Department of Treasury, as previously stated, those who work for the national government has been lawfully levied with the federal income tax per the legislative intent of the 16th Amendment. The legislative intent excludes American nationals from the federal income tax. Thus, sub silento, the election amounts to a gift or bequest as it was never mandatory. So you're giving them a gift, it's a donation, okay? So yet we see that the U.S. Department of Treasury states the federal income tax is a gift or bequest, indicating a matter of choice for American nationals, aka non-resident alien individuals, to donate or gift or bequest to use for the use of the national government. Now, mind you, we do actually fund these people, especially when we do the UCC1 process. We send them in hundreds of millions of dollars worth of bonds that they do, in fact, use to run the fucking country, all right, which is due back to you as well. Keep that in mind, all right? So, for the use of the national government or to freely ignore making a donation. The existence of both lawful taxpayers established via the legislative intent of the 16th Amendment and lawful non taxpayers, American nationals excluded by the legislative intent of the 16th Amendment, is dramatically evident. 31 USC Clause 321 D1 and D2 clearly illustrates that the federal income tax is considered and acknowledged by the U.S. Department of Treasury to be a gift that is paid for the express purpose and use of the statutory United States. Here is the exact statutory statement by the U.S. Department of Treasury as promulgated in the United States Code, Title 31. And then we'll get into this right here. So right here we have 31 USC Clause 321 D1 and D2. Number one, the Secretary of Treasury may accept, hold, administer, and use gifts of the property, both real and personal, for the purpose of aiding and facilitating the work of the Department of Treasury. Gifts and bequests of money and the proceeds from sales of other property received as gifts shall be deposited into the Treasury in a separate fund and shall be dispersed on order of the Secretary of Treasury. Property accepted under this paragraph and the proceeds thereof shall be used as nearly as possible in accordance with the terms of the gift or bequest. Number two, for purposes of the federal income, estate and gift taxes, and that's something to know too. The gift estate taxes, that's what they are, and you can write those off as well. The gift and estate and gift taxes, property accepted under paragraph 1 shall be considered a gift or bequest to or for the use of the United States. Let it be further known that the expression of the United States Department of Treasury reference to the statutory term United States in 31 USC Clause 321 D2 means and references only the national government in the District of Columbia and not the 50 states of the Union per 26 USC Clause 7408D. The IRS statutes refer only to the statutory United States being the District of Columbia unless a statutory section specifically refers to the 50 United States. The statute section reflecting this fact is 26 USC Clause 7408D. So, and this is what it is 26 USC 7408D. Citizens and residents outside the United States, if any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for the purposes of this section as residing in the District of Columbia. Uh, the above IRS statute in Title 26, it acknowledges the limited geographical and legislative jurisdiction for the application of the federal income tax to be only the District of Columbia and other U.S. territories and possessions of the national government. It entirely excludes any reference to the constitutional republic and the 50 states of the Union. Stipulation of facts established by the national government for American nationals. Revocation of election. All federal income taxation statutes and regulations apply only within the jurisdiction of the District of Columbia, the seat of the national government, also known as United States, unless directly stated otherwise. Sovereign American nationals are not subject to the statutes and regulations, particularly titled 26, uh, as they are limited in their geographical and legislative applications to the District of Columbia, as sovereigns are the author and source of law, according to the United States Supreme Court in Yick Woe versus Hopkins, 118 USC 365, 1886. All right, so that's how that goes. Now let's get into the statutory definitions of person. So the statutory definition of person, so this is the all caps person. The statutory definition of the all caps person is used in statutes within the Internal Revenue Code of 1954, currently in use today in the territorial jurisdiction of the District of Columbia, do not include or make reference to the American nationals. As a result of the territorial limitations placed against the national government per the Constitution, such statutory words or phrases that illustrate this fact are are highlighted in part as follows. Number one, person, defined at 26 USC 7701 A1, only referencing statutory legal fictions. Number two, U.S. person, defined at 26 USC 7701 A30, only referencing statutory legal fictions. Number three, taxpayer, defined at 26 USC 7701 A14, references any person, quote unquote person, subject to. Okay, so the taxpayer is going to be the person, it's going to be the legal fiction. So number four, U.S. citizen, defined at 8 USC 1401 A1, only referencing a statutory legal fiction that was legislatively born in the District of Columbia and are property of the national government and thus under the dominion or control of the national government within its limited geographical and legislative jurisdiction. This is clearly illustrated in 3 CAM uh, Jurisprudence, second edition, 2689 for U.S. citizens. And so we got D here. So as a result of the United States Supreme Court decision in United States versus Cooper Corporation, the term person does not include the sovereign, and that statute does not, employing the phrase, are ordinarily construed to exclude it. The statutory term non-resident alien, obtusely defined 26 USC 7701 B1B, was purposely stated in vague terms as it addresses sovereign American nationals as the target of that definition without reference to the term sovereign specifically. E. The implementing regulation 26 CFR clause 1.871-1A makes reference that non-resident alien individuals can only be liable for the statutory laws of the jurisdiction of District of Columbia if they choose to work for the national government. Therefore, only federal workers derive income that is effectively connected with the conduct of a statutory trade or business within the District of Columbia. All right. F. The 13th Amendment to the United States Constitution outlaws and prohibits slavery and involuntary servitude in the constitutional republic. It, however, does not outlaw voluntary indentured servitude. Okay, so that's you contracting in. It does not outlaw that because you're able to contract as you wish. The national government has utilized sub saliento acts directed at American nationals to induce them by prevailing social custom and lack of awareness of the facts established by law to draw into jurisdictions such as American national. 26 CFR Clause 1-871 1A reflects the deception by the use of a statutory election of a voluntary nature in order to make American nationals liable for the federal income tax when the national government was denied and deprived of such power by the United States Supreme Court in Pollock versus Farmers Loan and Trust Company in 1895. All right, so that's when it was fucking established, and they still been pushing that nonsense. So the legislative intent of the 16th Amendment, written by former POTUS William H. Taft on June 6, 1909, documents the limited jurisdiction for the national government to levy the federal income tax only upon itself. The federal income tax cannot and does not extend into the jurisdiction of the current 50 states of the Union. By ignoring the rule of apportionment, the only operational jurisdiction for application of the federal income tax is the District of Columbia and U.S. territories. You guys starting to get an idea of what the fuck's really going on here? Starting to see how this shit works? So, and then G, as evidenced by the national government cannot keep sovereign American nationals so entrapped by the use of the statutory election created by filing of a federal income tax return in perpetuity, meaning that to make you keep on doing it. So the national government has devised in its statutes a path for American nationals referred to by the national government as non-resident alien individuals to exit, depart, and terminate forever the federal income tax scheme by use of 26 USC Clause 6013 G4A, termination of election by the taxpayer. The H, the United States Department of the Treasury, an agency of the national government, is directly complicit in the statutory election scheme as stipulated in its statutes at 31 USC Clause 321 D1 and D2 by clearly stating the federal income tax is nothing more than a gift or bequest of national property money of a American national to and for the use of the United States, meaning the national government. The statement eliminates the exposure of the national government to legal action against the government by making the election voluntarily and then declaring that the money paid for the tax is nothing but a gift at the same time. So they're saying that it's an obligation for you to pay and you have to do it, and then they take it and they say thank you for the gift. You see the fucking game? Get the fuck out of here. So here we go. So the national government's use of statutory words is purposely obtuse for many sovereign American nationals not trained in the art of legalese, which is fucking word games. And that's all that they do. It's a bunch of word games. It's lesser magic. All right. They're putting spells on you essentially. So the statutes are written in such a manner to allow the American nationals to, by default, use their own definition of non statutory words to be misinterpreted as having the same meaning as what the national government defines their statutory words to mean. And this is what they do as well. So they go ahead and make up their own dictionaries and they use black law to fucking define the words that they use. And then they bring you to school, the public schools, and they give you a Webster's dictionary, a completely different dictionary. So that way your understanding of the words are completely wrong. As a result of the convoluted semantic gamemanship of the words defined by the U.S. Congress, the path to escape the entanglement of the American nationals into being identified statutorily as taxpayers of the federal income tax was discovered at 26 U.S.C. Clause 6013 4A. This revocation of election is now implemented by and in order to extricate himself forever from any obligation created by the former sub silento election. The existence of lawful non-taxpayers as related to the Internal Code of 1954 is described in two specific federal documents. The legislative intent of the 16th Amendment, written by former POTUS William H. Tapton on June 6, 1909, was promulgated in the Congressional Record of the United States Senate on pages 3344 and 3345. This foundational document proves that the federal income tax as we know it today was never lawfully designed to be levied upon American nationals. In fact, the power of the national government to do so was specifically denied to the government. American nationals were protected from the national government attempting to include them as being subject of the object of those federal statutory and regulatory laws. Economy, Plumbing, and Heating versus U.S. 470 F2D 1972, in which this appellate court declared the existence of two groups related to the federal income tax. Those groups are taxpayers and lawful non-taxpayers. Those American nationals, the lawful non-taxpayers, were stated by this federal court to be neither the subject nor the object of federal revenue laws. All right? So, are you guys starting to see what's going on here? The games, the games. So let it be lawfully established by the presentment of this personal testimony. XYZ expresses his desire to formally terminate the former statutory election via revocation of election. Revocation by taxpayer, non-resident alien, meaning American national, who by a prior sub salento government action made an election to have their earnings treated or taxed like that of a not like that of a resident alien. So why would anybody knowingly go into a contract where they're going to be treated like less than just for the fuck of it? Cut it out. So 26 USC Clause 6013 G4 addresses the termination of election with a pertinent section at 26 USC revocation by taxpayer. This statutory section stipulates that an election under this subsection shall terminate at the earliest of the following times. The earliest times mean 2 nanoseconds after the IRS receipt of this affidavit. So right away. So XYZ does hereby expressly state his desire to terminate the election made years ago via the congressionally created statute in 26 USC Clause 6013G. Even though the statutory election was never stated openly prior to that election, his desire to terminate the election is now clearly stated to those appropriate IRS operational personnel, IRS management, IRS chief legal counsel, and the IRS commissioner as stipulated at 26 USC Clause 6013 G4A, has now declares forevermore that he has exercised the option to terminate the election and upon the receipt is no longer identified as one taxable like a resident alien. According to the Internal Code of 1954, statutes promulgated at 26 USC 6013 G6, only one election, one finds expressed in this particular statute that if any election under this subsection is terminated under paragraph 4, termination of election, what do we got? Termination of election, revocation by taxpayers, that such individual shall be ineligible to make an election under this subsection for any subsequent taxable year. Thus, once a termination of election occurs, which is the purpose of this testimony properly submitted to the IRS commissioner, that can never again make an election to become a taxpayer in the future. So basically saying that once you elect to become a non-taxpayer, you can never turn back around and then just fucking become one. All right. It's just not legal to do so. So the Federal Appeals Court, Second Circuit, revenue laws, revenue laws relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for those non-taxpayers, and no attempt is made to annul any of their rights or remedies in due course of law. With them, non-taxpayers, Congress does not assume to deal, and they are neither the subject nor the object of federal revenue laws. Now reaffirms the desire to express intent to revert back to his rightful status of an American national who is neither subject nor the object of federal revenue laws. So you're starting to see here the whole point of this affidavit is to get yourself out of the election that you probably unknowingly made to become a taxpayer. All right. So imagine how much money you'd actually have if they weren't fucking taking half your checks every week. So let it be established by this testimony the express purpose and revocation of election is a sovereign American national and become so by birth in one of the 50 states of the Union, birth to one parent or more who were born in the 50 United States, or naturalization. He is not subject to the territorial jurisdiction of the statutory United States, the District of Columbia, as a result of birth in one of the 50 states, the constitutional republic. That's where we all live. He is an American national who is a non-resident, geographical and statutorily speaking, to the District of Columbia. He is also an alien to the legislative jurisdiction of the U.S. Congress, who creates legislative acts without direct reference to actual jurisdiction, and that's what they always do. They just make laws, fucking throw them shits up in the air, and hope somebody reads them and thinks that they're going to be subject to them. All right, it's crazy. Congressional laws are of limited jurisdiction. The Supreme Court declared all federal statutes and regulations apply only within the territorial jurisdiction of the United States, the District of Columbia, unless a contrary intent appears. He is a sovereign American national and is not subject to the statutory laws promulgated for the use in the exclusive and limited jurisdiction of the United States of the District of Columbia. the seat of the national government. Furthermore, being a sovereign American national, he is not referenced or included in any statutory laws related to federal income tax created by U.S. Congress. He cannot be compelled, goaded, or presumed to associate with the national government, which would be a direct violation of the Foreign Sovereign Immunities Act and the 13th Amendment of the Constitution, outlawing slavery and involuntary servitude in the 50 states. The legislative intent of the 16th Amendment to the Constitution clearly states that the federal income tax was only levied upon the national government, meaning that those who choose to work for the government, the narrow the narrow jurisdictional application of the federal income tax is evident and uh, due to the amendment, referring that it does not require adherence to the constitutional requirement of apportionment based on census and would be required of any direct tax. The Congressional Act of the 16th Amendment avoids this limitation in the Constitution by only applying the amendment to the jurisdiction of the District of Columbia, the statutory United States. The legislative intent of the 16th Amendment acknowledges that the former POTUS William H. Taft on June 16, 1909, recognized this territorial limitation for the levy of the federal income tax. The legislative intent of the 16th Amendment can be located in the Congressional Record of the United States Senate on pages 3344 and 3345. He does not derive any income that is effectively connected with the conduct of a statutory trade or business within the District of Columbia. He has no physical or statutory federal domicile within the District of Columbia. You don't live there, you don't work there. So why the fuck would you have to pay a tax to them people? You're not even from there. The national government and its bureau, the International Revenue Service, lacks both geographical and legislative jurisdiction to apply the federal income tax upon any American national according to the legislative intent of the 16th Amendment. The U.S. Supreme Court and the Office of the Federal Register and the enacted federal tax laws presented have never been made liable for the federal income tax by enacted federal law except via the subsequential election based on presumptions of its existence. So he has discovered that the statutory option provided by the U.S. Congress at 26 U.S.C. Clause 6013G and its subsections and does now revoke the election that was the etiology for the infectious financial statutory disease that has resulted in loss of compensation for my labor over many years created by the national government. And basically, what they're doing is stealing your energy and they're stealing your fucking life from you. All right, if you want to look at it like that. So, this revocation of election hereby made XYZ is effective immediately and is presented to the office of the IRS commissioner, etc., within the Bureau of the International Revenue Service. As a result, the Internal Revenue Service has been effectively noticed of the revocation of election and that per 26 USC Clause 6013 G6, the revocation of election is now permanent. Never again can he be coerced, compelled, or goaded back into the nefarious created statutory scheme of the national government. He must now be properly identified by those within the Internal Revenue Service as one who is a lawful non taxpayer, and that the scope of the statutory revenue laws within Title 26 are not applicable toward him. The Internal Revenue Service now recognizes by the revocation of election that he is neither the subject nor the object of federal revenue laws. The Internal Revenue Service is now formally notified and put on notice of the revocation of election by XYZ and therefore can no further discussions as to his ever being liable for making a federal income tax return. The IRS records and databases must now reflect this termination of election, and all Chapter 24 withholdings must cease for all time in compliance. Revocation of election is now legally established. XYZ has now properly followed the statutory instructions at 26 USC Clause 6013 G4A as was created by U.S. Congress in ending his former participation in the federal income taxation scheme, which was initially established via subsequential election, meaning voluntary election. Congress and the IRS, now by statutory requirements, recognizes his unalienable rights as a lawful non-taxpayer of the congressional income taxation statutes and regulations. So you see what's going on here. And this is a great affidavit to go ahead and put together. And the last page we have here basically is just the last part of his affidavit. You can go ahead and edit this to your liking and to your particular situation, and just make sure that you do all your due diligence and know exactly what it is that you're doing before you engage these people. All right, because there are a bunch of dickheads over there sometimes. Not all the time and not all of them, but they can definitely be dickheads, especially if you're dealing with somebody who has no clue what the fuck that they're doing. You know what I mean? So remember, man, if the game of chess, stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.